Works contracts are agreements where a contractor undertakes to execute a project involving both supply of goods and services. For example, building a house, installing a solar panel, or laying a pipeline. Before July 1, 2017, works contracts were taxed under the value-added tax (VAT) regime, which varied from state to state. The VAT rate for works contracts in Karnataka was 5.5%. However, after July 1, 2017, the Goods and Services Tax (GST) replaced the VAT regime and introduced a uniform tax system across the country. The GST rate for works contracts was fixed at 18%, which was much higher than the previous VAT rate. This created a problem for contractors who had entered works contracts before July 1, 2017, but had not completed them by that date. They were faced with the dilemma of either absorbing the increased tax burden or passing it on to their customers, who may not agree to pay more. To resolve this issue, some contractors approached the Karnataka High Court and challenged the applicability of GST to their ongoing works contracts. They argued that the GST law violated their right to freedom of trade and commerce under Article 19, 1G of the Constitution. They also claimed that the GST law amounted to double taxation, as they had already paid VAT on the goods supplied under the works contracts. The Karnataka High Court agreed with the contractors and ruled in their favor. The court held that the GST law could not apply retrospectively to works contracts that were entered before July 1. The court said that such contracts were governed by the VAT regime and could not be subjected to GST without violating the principles of natural justice and fairness. The court also observed that imposing GST on such contracts would result in double taxation and undue hardship to the contractors. The court's ruling was a relief for many contractors who were facing a GST nightmare due to their ongoing works contracts. The ruling also clarified the legal position on the transition from VAT to GST for works contracts and upheld the constitutional rights of the contractors. The court also directed the government bodies that awarded the contracts to bear the differential tax burden that arose after the GST regime kicked in, on the grounds that taxes were not part of a contractor's profit. This was a significant relief for the contractors who had entered into works contracts before July 1, 2017, when the GST replaced the VAT regime. Under the VAT regime, the contractors paid 4% or 5% tax under composition scheme or 12% tax as per their case.